Out of the vehicle, please. All I want to do is talk to you.
Then talk to me.
Get out of the vehicle. Do it now, man.
I'm recording you.
I'm asking you to get out of the vehicle. Okay, look. I'm going to ask you one more time. Then you will be placed under arrest. So you need to get out of the vehicle. I don't want to talk to you right now. Do me a favor, get out of the vehicle. I just want to make sure that you can operate this vehicle safely. If you don't, what I'm going to do is I'm going to place you under arrest for resisting. Okay? Right now you're being detained.
For what?
You're being detained.
For what?
Because I smell alcohol in your breath, that's why.
Well, that's a damn lie.
Hello, and welcome back to Legal Dissent, where we evaluate your constitutional rights before they're taken away. Thank you all so much for joining us, and as always, if you enjoy our content, please do consider subscribing, liking this video, and interacting with us in the comments below. It really does help us out a lot in the YouTube algorithm and allows us to create even more videos for you to enjoy. I am really excited to announce an upcoming collaboration with another YouTuber that'll be coming out later this week. Stay tuned for details, but I know that you are absolutely going to love it. This video was submitted to us by a subscriber via Facebook. If you have any videos you'd like us to evaluate, send it our way via Twitter, Facebook, or email. All of our contact information, as well as all of the case law, statutes, and other sources used in this video are located in the description. Michael and his girlfriend were at the Cameron County Beach in Texas on June 21st earlier this year when they pulled over because he was using his phone to get directions. Officer Hernandez approached the car, allegedly smelled alcohol in the breath of the driver, and then demanded that the driver exit the vehicle.
You now, you smell like alcohol, get out of the vehicle.
That's lies.
Oh my God.
That is a lie.
Oh, that's what the
Vehicle, please. All I want to do is talk to you.
Then talk to me.
Get out of the vehicle. Do it now, man.
I'm recording
I'm asking you to get out of the vehicle.
You can talk to me right here. I didn't do anything. You literally came over here and I just...
Run a 27 check, Texas my number. 4230.
You're trying to give it for alcohol that's not even open?
4230-9320. Okay, look. I'm going to ask you one more time. Then you will be placed under arrest. So you need to get out of the vehicle. I don't want to talk to you right now. Do me a favor, get out of the vehicle. I just want to make sure that you can operate this vehicle safely.
There are a few caveats to this situation. First, the individuals in the car were voluntarily stopped. The officer did not pull them over, but according to his police report, the vehicle was parked halfway on the improved shoulder and the soft shoulder of the road. But due to the extreme traffic, the vehicle did pose a traffic hazard. The officer alleges that he observed the vehicle parked for a prolonged period of time, with traffic forming behind it into two lanes of traffic. At that point, the officer decided to make contact to have the car moved to a safer location. Thinking that it might be disabled, he activated his lights and approached the car. It is legal for officers to approach stopped cars in the shoulder in situations like this, especially if what the officer claims is true, and that there was traffic forming behind the car and it posted a potential traffic hazard. That being said, there are always three types of police-citizen encounters: consensual conversations, detainments, and arrests. Consensual conversations are legally allowed to happen at any time for any reason without any justification. This officer in this situation activated his lights not to detain the driver but to alert passers-by of the stopped car. Second, consensual conversations with officers escalate to detainments when the officer has reasonable, articulable suspicion that criminal activity is occurring. According to the police report, he detected a very strong odor of alcohol emitting from inside the vehicle. He observed two 16-ounce cans of Dos Equis beer lying on the driver's side floorboard, and he alleges that the driver's eyes were bloodshot. Now, none of these factors in and of themselves create probable cause for an arrest. A strong odor of alcohol, if it actually existed, could be hand sanitizer, could be coming from the passenger, or could be a beach towel that some other person spilled an alcoholic beverage on. The beer cans were unopened, and according to Texas law, you are allowed to have unopened containers of alcohol in your car for transport. There are a myriad of reasons why someone might have bloodshot eyes apart from being drunk. However, all of these factors, while not proof of a crime, does create reasonable, articulable suspicion for the officer to investigate further. Therefore, in my opinion, the officer does have the right to detain the driver to investigate further to make sure he was not impaired. There is one further caveat for those of you in the YouTube comments section clever enough to pick up on the fact that the officer did not actually witness the individual driving. The car was already parked before the officer witnessed it, so can an officer detain a parked individual even if he is not driving? Texas Penal Code Section 49.04a provides the person commits the offense of driving while intoxicated when the person is intoxicated while operating a motor vehicle in a public place. According to the Texas Court of Criminal Appeals in Denton v. State, a person is operating a vehicle when the totality of the circumstances demonstrate that the defendant took action to affect the functioning of the vehicle in a manner that would enable the vehicle's use. Now, what does that mean? They look at if you were in the driver's seat or in the back seat sleeping. Is the engine running? Where are you? On the side of a highway or in your own driveway? Where are the keys? Do you have the seatbelt on? In this scenario, the court would find that Michael was operating the vehicle.
If you don't, what I'm going to do is I'm going to place you in arrest for resisting. Okay. Right now, you're being detained.
For what?
You're being detained.
For what?
Because I smell alcohol in your breath. That's why.
Well, that's a damn lie.
Get out.
I can take your breathalyzer.
Okay, I've got one of those. Get out of the vehicle.
Bring it here then.
Get out of the vehicle, man. Don't make this worse. You're just making worse on yourself. That's all you're doing. I have another unit en route. If I have to force you out of the vehicle, I will. All I want to do is talk to you right now. Get out of the vehicle.
What's this you were talking to you right here, right now?
Get out of the vehicle. I smell alcohol. Get out of the vehicle. I'm going to tell you one more time, and it's going to get worse.
Come on.
Get out of the vehicle. Get out of the vehicle.
I want one of the sheriffs or the managers over here. I'll wait.
I'm a supervisor. I'm telling you to get out of the vehicle right now. Get out of the vehicle. I will place you in arrest.
I didn't do anything.
Get out of the vehicle.
Michael, stop.
I'm going to tell you one more time, and then you will be forced and you will be charged. Get out of the vehicle. Get out of the vehicle. I'm going to tell you one more time, and then it's going to be tough on you. I'm telling you.
You're the one that did it.
Michael.
Get out of the vehicle.
Record. Look at.
Get out of the vehicle.
Record the alcohol.
Get out of
Nothing's
the
opened up.
vehicle.
I'm of age.
Get
My name is
out.
Mike.
Michael, please get
Get out of the vehicle, man. I'm telling you right now. Get out of
Stop.
the vehicle.
Stop. Get out.
You're the one causing
Michael,
the scene.
please get out.
You're the one causing the scene, man.
Michael, stop.
Get out of the vehicle.
I'm waiting for other officers to get here.
Get out of the vehicle.
The United States Supreme Court held in Pennsylvania versus Mims that the analysis of Fourth Amendment rights are always determined by the reasonableness in all of the circumstances of the particular governmental invasion of a citizen's personal security. This reasonableness depends on a balance between the public interest and the individual's right to personal security free from arbitrary interference by law officers. In Mims, the officer had no reason to suspect foul play from the driver, and there was nothing unusual or suspicious about the driver's behavior. This officer, however, made it a practice to order all drivers out of their vehicles as a matter of course whenever they had been stopped for a traffic violation. The court recognizes that the governmental interest in keeping officers as safe as possible when exercising their duties is an important interest. And note that a face-to-face conversation with the driver makes it less likely for the officer to be assaulted and also less likely to be hit by traffic if they pull the driver to the shoulder. They then weigh the governmental interest versus the intrusion into the driver's personal liberty of being removed from the car. The court held that the additional intrusion created by the order to get out of the car was de minimis. The driver is being asked to expose to view very little more of his person than is already exposed. The police have already lawfully decided that the driver shall be briefly detained. The only question is whether he shall spend that period sitting in the driver's seat of his car or standing alongside it. Therefore, it is not a serious intrusion upon the sanctity of the person. So yes, per the Supreme Court's decision in Mims, if you are asked to exit the vehicle by a police officer who has legally detained you, then you must exit the vehicle. In this situation, the driver has been legally detained and has been given an opportunity to exit the car. Therefore, in my opinion, the driver should have exited the vehicle when asked per the Supreme Court's ruling in Mims.
Stop, stop, stop,
Okay.
stop, stop,
You're gonna go
stop,
like this?
stop,
You're
stop,
the one causing the
please.
scene.
Stop, please get out, Michael.
You want to do it like this?
I'm waiting for other officers to get here.
Okay. I'm going to tell you one
Call
more
the
time.
cops.
No,
Call the cops.
please.
Call the cops.
Fine.
Now you're
Oh,
under arrest.
Call the cops.
Look,
oh, stop,
you're
stop,
fixing
stop,
to get
stop,
maced.
stop.
You're fixing to get OC. Get out of the vehicle.
For what, bro?
Get out of the vehicle because I smell alcohol on your breath. Get out of the vehicle.
Just do it.
You said you want to take a breathalyzer.
Get out of the vehicle. I'm going to tell you one more time, then you're going to be maced in your face.
Please do it, Michael.
Get out of the
Are
Stop.
you threatening me, bro?
Stop, Michael.
I'm going to put it on you.
Are you threatening me?
Oh
Get out
my
of the vehicle.
God.
Get out of the vehicle.
I have the right to defend myself.
Get out of the vehicle.
Stop.
I haven't
get
done
out.
anything illegal.
Get out of the vehicle.
You're trying to arrest me on what?
You're being detained. Get out
On
of the
something
vehicle.
that you say that you smell that you
Get
haven't
out
even
of the
gone
vehicle.
inside the vehicle?
Get out of the vehicle. Get out of the vehicle, man. I'm telling you.
Hey.
I will get a lawsuit against you.
Michael,
Get out of the vehicle.
please do it.
Get
I
out
don't
of the
want you to
vehicle
hear,
now,
please
man.
Stop.
Get
Get
out of the
out.
vehicle.
I'm waiting for other officers.
Get out of the vehicle.
I'm waiting for other officers. I don't trust you.
Now you're under arrest, man.
Stop.
I don't trust you.
Michael.
Now you're under arrest.
I don't trust you.
Get out of the vehicle, man. You're just making a scene.
You are. You're the one that called.
Now you've got resisting charges. All I don't want to do is talk to you. You smell like alcohol.
I can talk to
Get
you.
out of the vehicle now.
I'm waiting for other
Get out of the
officers.
vehicle now.
Michael.
Get out of the vehicle now.
If I was
Oh
doing
my
something
God.
Get out of
illegal,
the vehicle now.
you would have done something about it by now.
Get out of the
Oh
vehicle
my
now.
God, please.
Get out of the vehicle now.
Hey,
Michael, get
I
out.
haven't done anything.
Get out of the vehicle, Michael. Get out of the vehicle now. Get out of the vehicle.
You have my ID. You
Get
see
out of
that
the vehicle now. Get out of the vehicle, man. You're seconds from being OC'd. And I'm going to charge you. Get out.
Please get out.
Charge me for
Please
what?
get
Get
out.
You have no right to wait for a police supervisor. There is no federal or state law that mandates police have a supervisor on scene if requested. While individual departments may have policies that require a supervisor to respond, this is not a right or a liberty that you are entitled to, and it won't be a get out of jail free card if you get into trouble. The officer goes on to pepper spray the driver, and the driver was arrested and charged with resisting arrest and search, and he is awaiting his court date later on this year. It is strange that the driver was not tested for alcohol after his arrest, and it indicates that the driver was not actually impaired. So it seems that this arrest comes down to a young man being combative with the police and refusing to do what they told him to do. According to the law, my opinion is that this arrest will probably stand. There's very little wiggle room in MEMS, and the officer did have reasonable, articulable suspicion for the detainment. What do you think? Should people be required to exit their vehicles simply because an officer asked them to? Does it actually keep officers and people safer? Let us know in the comments below. And remember that no matter who you are, you have value and you have rights. Do not be afraid to use them, and we'll see you next time right here on Legal Dissent.